Welcome to the AI Policy Podcast, a podcast by the Wadhwani Center for AI and Advanced Technologies at CSIS. I'm Gregory C. Allen.
And I'm Andrew Schwartz.
Join us as we dive into the world of AI policy, where we'll discuss the implications of this transformative technology for national security, geopolitics, and global governance. Welcome back to the AI Policy Podcast. I'm your host, Gregory C. Allen, the director of the Wadhwani Center for AI and Advanced Technologies here at CSIS. And today we've got an episode all about the intersection of AI and intellectual property policy. And we've got one of the best people you could possibly get on planet Earth to talk about this issue. We've got Andrei Iancu, who is a partner at Sullivan and Cromwell, a major law firm with a big practice here in D.C., and he is a partner in their intellectual property and technology practice. He's also a former Undersecretary of Commerce for Intellectual Property and director of the U.S. Patent and Trademark Office, or the USPTO. So in his role as the Undersecretary and the director of USPTO, Mr. Iancu led an agency with approximately 13,000 employees and an annual budget of more than $3.5 billion. He was also the principal advisor in the administration on domestic and international intellectual property policy matters. So he's perfectly positioned to talk about this because a lot of important AI decisions took place while he was in charge, and he's been looking at these issues closely since he left government. Andrei, I should say, is also a senior advisor of the Renewing American Innovation Project here at CSIS, and so a member of the greater CSIS family. So, Andrei, thank you so much for coming on the podcast. Andrei, you've had a very long career in multiple different parts of intellectual property law and policy. I'd wonder if we could just hear a little bit more about you. You heard how I introduced you a moment ago, but I'm curious, over your career, what are some of the major intellectual property policy debates that you've been a part of and that took place perhaps while you were working in government?
So thank you, first of all, for that very kind introduction. Well, let me just go back a little bit. Like most patent lawyers, I started as an engineer first. I have degrees in aerospace and mechanical engineering, and first worked for a number of years at Hughes Aircraft, building antennas for satellites. And,
what is now Boeing Space Systems then?
Yeah. Well, after I left, Boeing acquired Hughes Aircraft, among other things. Yeah, but that's exactly right. So then I went to law school and then became a lawyer. And as I said, like most good former engineers, I became an IP lawyer. And I did that for about 20 years in private practice. I focused then, and actually I do now, on all aspects of intellectual property, but primarily litigation. So that's just a brief, very high-level overview of my career path. But to answer your question about policy issues that I've seen over the course of my career, in the patent system, there's a saying that patent laws and patent policy is on a pendulum. And the pendulum swings between policies that favor more the patent owner on the one side versus policies that favor more the consumers of that innovation on the other side. I've observed it's been now, since I graduated law school, 28 years, I would say. And over, almost 3 decades, there's no question that we see this swing in policies. And there are many, many examples of this that we can go through during the course of this conversation. But fundamentally, the reason this is happening is that patent law, and indeed all intellectual property laws, represent a tension between the innovators or the creators and their legal needs and the consumers of that creativity. Now, if you go back to the founding of the United States, the concept of intellectual property laws appears in the Constitution, in Article 1, Section 8, Clause 8, where the Constitution gives Congress the power to create IP laws in order to incentivize what they call the progress of science and useful arts. and to give authors and inventors their respective rights to their creations. And in the Federalist Papers, James Madison recognized this tension, but he wrote that the rights of the individual creator fully correspond with the rights of the public. Nevertheless, so he was trying to resolve that tension and gloss over it to some extent. And we can argue as to whether they correspond or not, but the reality is that if the rights are too strongly in favor of the creator, then the creator can charge higher prices. If they are too far towards the consumer, then there's not enough benefit to the creator, and there will be less creation on the margins, less innovation. The bottom line is, over the span of 30 years of my career, this tension has always resulted in these swings. And the best case scenario is if you can balance and put the pendulum right in the middle, but that's always difficult to do.
That's fascinating. Okay, we're definitely going to get to that tension. We're definitely going to get to how that tension is currently being reflected in the innovation going on in the AI sector. There's one thing I want to get a little bit of background and context on. I think everybody who's listening to this podcast knows what a patent is. Probably everybody also knows what a trademark is. But I don't think everybody knows how the U.S. Patent and Trademark Office actually works. And so I'm curious if you could help me understand, what do these 13,000 employees actually do? What is the machinery? What is the process by which the United States manages, what you called that useful tension between supporting producers of innovation and supporting consumers of innovation? How does all that actually work?
Yeah, so first of all, the various intellectual property rights, you have patents which cover inventions, usually with respect to technological creations, industrial creations, on the one hand, what the Constitution calls the useful arts. Then you have copyrights, usually on the fine arts, right? Songs, books, movies, paintings, photographs, etc. Those are subject to copyright. Then you have trademarks. Trademarks indicate a source of origin. You see a name, a brand, you automatically know who the manufacturer is. So you protect those brands, the names, or the shape or the look of a particular item, as long as it can identify a source of origin. Then there are some other intellectual property rights, such as trade secrets and the like. The U.S. Patent and Trademark Office handles two of those, and that is patents and trademarks, obviously. And the role of the office is to, number one, examine and issue patents, examine patent application and issue the patents that are meritorious. And number two, examine trademark applications and register trademarks where appropriate. So there are 13,000. There's approaching 14,000.
And then who handles copyrights?
So copyrights are handled by the United States Copyright Office. It's a separate office. Interestingly enough, the Copyright Office is actually not part of the administration. It is part of the legislative branch. And that's a doozy, Gregory. If you think back to your constitutional classes from high school, you're supposed to have a divided government with three branches, right? The legislature makes the laws, the administration enforces the laws, and the courts interpret the laws. Well, here we have the Copyright Office, which registers copyrights. It
feels very,
laws, yet it's in the legislative branch. But that dates back to Thomas Jefferson, when he donated all his books and created the Library of Congress.
Amazing.
Anyway, so put that aside. So 13,000 people, almost 14,000 in the PTO now. And the vast majority of them, about 10,000 all in, are dedicated to reviewing the patent and trademark applications that come in, studying them vis-a-vis the statutes. Do they comply with our laws? And are they new and meritorious so that they deserve the protection of the law? So that's the vast majority of the work that the office does. That's about, as I said, 10,000 people. 9,000 plus of them do the patent work, and about 1,000 or so do the trademark work.
Mhm.
Then on top of this, we have appellate bodies, right? We have a trademark appellate body that reviews what the examiners, the trademark examiners have done if the applicant is unhappy with that result. And we have a patent appellate body that reviews what the patent examiner has done if the patent applicant is unhappy with that result. So we have those additional bodies. Then obviously the PTO has, like any other agency, a finance group and
Right.
an IT group and everything else to get us to 13,000.
Yeah, that's great. Okay, so that's something I knew somewhere had to be handling all of this, but who and how, I'm learning at the same time the audience is. So now we're going to shift gears and talk about the intersection of AI and intellectual property. President Biden recently passed an executive order on this. We're going to talk about that. But first, just in your own mind, how would you sort of summarize the intersection of AI technology and intellectual property debates? What is your sort of view of the debate landscape?
Okay, so the most important thing we have to do, first of all, is define what we are talking about.
Mm-hmm.
Number one, it would be, everybody talks about AI all the time nowadays, in every context, including intellectual property. So the first question really is, what is AI?
Mm-hmm.
Okay, what are the boundaries of this thing we call AI? Obviously, we're using computers all the time. We use our cell phones all the time. They are full of, quote, automated intelligence,
Mm-hmm.
if you want to call it that. We're using a computer technology as we speak right now to record this program.
Mm-hmm.
How much of this is AI, if any?
Yeah, the example that I always like to use is tax preparation software. When it first came out in the 1980s, was marketed very successfully as an AI accountant, and nobody questioned whether they were a professor of computer science or just an everyday consumer. Everybody sort of agreed that yes, this sort of thing counts as artificial intelligence. And today, tax preparation software we just call software. And if you call it artificial intelligence, people will look at you funny. So this is kind of a moving target in terms of how it's defined in everyday culture. But when it comes to the law, you need precise definitions that stay true.
Exactly, especially if we're going to have special laws for whatever we call AI as compared to the rest of the computing technologies.
Right.
We need to know where that line is drawn. That's the first point. The second point we need when we talk about AI and intellectual property is, what are we talking about with respect to the laws here? So number one, I put that into three buckets. Number one, intellectual property for the artificial intelligence itself, for the new computer programs themselves that are what somebody deems to be AI, right? They're new, they're novel, they're innovative themselves. And what kind of protection should we give, if any, to those new artificial intelligence technologies? Okay, that's the first bucket. Second bucket is the use of AI tools by humans to create innovations. Okay, so you are an engineer working, I don't know, at a satellite antenna company, and you're designing new components, satellite components. Are you, obviously nowadays almost everybody would use a computer, but are you doing more than that? Are you using an AI program to help you design that new invention? Same thing on the copyright side, where you might use an AI tool to create a new poem. People can do that now with ChatGPT, for example, create a new
Yep.
poem. Or use an AI tool to create a new painting. People do that nowadays too, or a new song. So again, the use of AI tools to create new innovations, new creations. And the question there is, should those new creations made with the help of AI tools, should those be protected by intellectual property laws? And if so, when? And when you talk about intellectual property, the third bucket is what AI tools, if any, should or could the US Patent and Trademark Office or the US Copyright Office use in examining applications, and what sort of tools can lawyers practicing in this space use to draft applications and submit them to the patent office or to a court of law and the like. This third bucket is the least important. It's good to know about that from a logistical and governance point of view, but the most important things for the public would be the first two buckets that I've mentioned.
Yeah. And I think, and this definitely falls into a mixture of the two things that you said, especially number two. But I think because AI is now generative AI, and generative AI is so widespread and so capable across many different things, there's the question of what constitutes when you're using AI to create what is quote unquote a new work, whether or not that is truly new or whether or not that is somehow a violation of somebody else's existing intellectual property rights. So just to give one example, I at one point wrote an article, and as a joke, I asked ChatGPT to translate that article into a rap song in the style of the Broadway musical Hamilton. And shockingly, the ChatGPT result was like pretty good. And part of the reason why it was pretty good is that it had all of the Hamilton lyrics in its training data set, I presume. I don't know that to be true for a fact, but I just presume because those are all over the internet everywhere, and the training data for ChatGPT is a lot of the internet. Well, the question then is this new poem, well, these new lyrics, right, that have been created by ChatGPT, is that something that I could copyright? Is that something that the creator of ChatGPT could copyright? Or is that something that Lin-Manuel Miranda and whoever else owns the copyright to the lyrics of Hamilton could sue me for a copyright infringement? Is that sort of a fair example of one of the common debates that we're seeing?
It's a good example, but actually there are many separate questions in what you have just articulated, and they're all very separate questions. The first question is that creation that you have just made copyrightable in the first place? Because you, the human being, Gregory, entered the prompt into the machine.
Right.
But then the machine, ChatGPT, in this example that you gave, generated the lyrics or the song, the new song. And let me just park that for a second and say that the law, as it currently stands, allows for patents and copyrights to be given only to human inventors and authors. The Constitution says that you can give copyrights and patents to authors and inventors. And the Supreme Court has interpreted authors and inventors to be human beings. And that has been, to this very day, very recently, the Court of Appeals for the Federal Circuit has spoken on this just in the last few months and agreed that they're human beings. So in your example, you entered the prompt, the lyrics are generated by the machine. Is that new creation done by a human being, by a human author?
Yeah, like was ChatGPT a tool that I used for my human creativity? Or was ChatGPT actually, quote unquote, the author? If ChatGPT was, quote unquote, the author, I think what you're saying is it would not be eligible for a copyright because human beings are the only types of authors that are eligible for copyright protection. Did I understand you correctly?
That's exactly right. So that's the first question. Really complicated, and we can talk about that. The second question is, does the new song that you just created infringe existing copyrights that are already owned by the original Hamilton author? And that's a separate question, right? Whether or not you have a copyright, the first question is one thing. But that doesn't matter. Now you have the song, and whether or not you have a copyright, you still can infringe
Okay.
Miranda's copyrights. That's a separate question. And you already see lawsuits by existing authors against ChatGPT as we speak right now. They're pending cases precisely for this issue, for this reason, that those original authors believe that the creations by ChatGPT are infringing on their existing copyrights.
Yeah, and one of those prominent lawsuits is the New York Times' lawsuit. And according to some of the evidence submitted by the New York Times to the court, they were able to insert certain prompts. I think in the main case, it was like the first few words of a New York Times article, and then ChatGPT would spit back out the rest of the article, which the New York Times was using as evidence that, number one, New York Times articles were in the ChatGPT training data set. And then number two, that the way that ChatGPT was giving out access to New York Times articles outside of the New York Times internet paywall was infringing upon its rights. What can you say about the sort of legal landscape of these types of lawsuits? We already have the high courts ruling about AIs can't invent anything. Is there anything that is settled when it comes to the types of questions raised by the New York Times lawsuit and other ones like it? Or is this all still very much up in the air?
It's completely up in the air. By the way, the first question is up in the air too. But this question is completely up in the air. There are these pending cases. It's pending litigation. There's not much I can say. We'll have to see how the courts resolve this infringement question. And going back to your original example, there are many other questions in there too. If in fact there is a copyright that you, Gregory, is entitled to for that new song creation, who is the owner of that? Is it you, Gregory, the human that entered the prompt? Is it the authors of the AI that really contributed a lot to this? And then it devolves from there. But those are the main questions.
That's really excellent. So thank you so much for outlining what are the major questions in this debate. And then we're talking on July 25th. And there's been a really big development in this area. So, in line with President Biden's executive order on AI that came out last fall, well, that executive order included some 90-day deadlines, some 180-day deadlines, and some 270-day deadlines. And the 270-day deadline is tomorrow. And so some of the agencies that were directed to complete their work have done so already. And one of those agencies is the U.S. Patent and Trademark Office. So on July 17th, the U.S. Patent and Trademark Office released updated guidance on the patent subject matter eligibility for AI. So for those in the audience who are unfamiliar with the term, myself included, what does it mean for an invention to be subject matter eligible, and how do patent examiners determine eligibility?
Okay, you're not asking any easy questions, Gregory. Humongously complex questions, but they're really important, and I love talk about them.
Talk to me as if I was a small child as you're explaining these things.
Okay, so let's just go back to basics, and let me try to explain eligibility at the highest levels. As I said, there are multiple forms of intellectual property protection, right? And again, the Constitution speaks of two, patents and copyrights, but there's a few others that have developed over time. But let's just focus only on patents and copyrights for this example. So some things are subject to patent, other things are subject to copyright. And it would be good to know where that line is.
Right.
Okay. Most of the time, it's easy to figure that out, right? You see you see a painting, clearly that's copyright. You see a new novel or a new poem, clearly that's the fine arts, that's copyright. On the other hand, you see the Wright brothers come up with the airplane. Clearly, that's a patent. You see a Thomas Edison with his light bulb. It's useful, it's practical, it's industrial. Clearly, that's a patent. Those are easy determinations. However, things in the middle, I'll give some examples in a minute, are very complicated to figure out where that line is. Eligibility is the very initial threshold question, which is, are we in patent land or are we in copyright or some other land?
Got it.
Okay, that's the first threshold question. And as I said, in the vast majority of cases, it's really easy. You have to ask the question every time, but the vast majority of the times, it's almost automatic. The U.S. Patent Office receives about 750,000 applications a year nowadays.
Wow.
It issues about half, a little bit more than half of those. The other half are not, for one reason or another, they don't get approved or allowed. But in every one of them that comes in, the 750,000, every single one, you have to ask the initial question. Are we in patent land to begin with?
Mm-hmm.
And as I said, most of the time it's an automatic yes or no. It's really easy, but sometimes it gets very complicated. Okay, so how do we do that analysis? The statute that determines what's patent eligible, okay, is in the patent code, 35 USC, United States Code 35, section 101. Okay, that patent code, believe it or not, was written, word for word as it is today, was written by Thomas Jefferson and James Madison as part of the Patent Act of 1793.
Wow.
Hasn't changed since.
They had a really good first draft, clearly.
Those guys were brilliant, obviously. And it basically says that we can give patents to 4 categories, okay, of creations: a process, a machine, a manufacture, and the composition of matter. That's what they wrote. 4 categories: process, machine, manufacture, composition of matter. Now, since then, technology has progressed a lot, right? In 1793, we lived in an agrarian society. Pretty much. We were barely at the beginning of the first industrial revolution. Now we are in the midst of the 4th industrial revolution, by the way some folks count. And as brilliant as Jefferson and Madison were, and they were, clearly, they still did not anticipate DNA testing,
right,
or analysis. They still did not anticipate artificial intelligence and the like. So when it gets to some of these 21st century technologies, it gets really difficult to figure out how they fit into the 4 categories outlined in an 18th century statute.
Yeah.
So the courts have said for a long time that there are some exceptions, even if they might fit into these 4 categories. There are some exceptions to what's eligible for patent. Okay? A law of nature, for example, is not eligible for patent. Or a pure...
So like when Isaac Newton discovers how gravity works in a mathematical sense, that's not patentable.
Exactly. So Newton sits under the apple tree, apple falls on his head, he says, aha, there's gravity. That's a brilliant discovery, but it's a discovery of nature. It's not a patentable invention.
Got it.
Okay. Whereas a practical application of gravity, right, employing the laws of physics to generate engineered products like an airplane or a rocket that uses the forces of gravity for them to work, an automobile, etc. We use gravity for it to work. The practical applications of those laws of nature, those are patentable.
Got it.
Pure laws are not. Same thing with pure mathematics. Pure mathematics, the courts have said, not patent eligible because mathematics by itself, math doesn't do anything.
Right.
By itself. It's just conceptual numbers. 2 plus 2 is really good to know that it's 4, but it doesn't do anything unless you apply it to something practical. Again, back to Newton. Newton is said to have invented calculus, okay? Or Leipzig, whatever, but both of them are credited by different people. Brilliant creation, calculus. but not patent eligible. By itself, it doesn't do anything. You need to apply it to something practical. And the third category that courts have said not eligible for patent, and most important for our AI issues, is courts have said that abstract ideas are not eligible for patent. In other words, just an idea. I have this brilliant thought in my mind about a new technology. For example, I can tell you, Gregory, I've invented, okay, a spaceship to Pluto that gets there in a fraction of a minute somehow. Well, that's fantastic, you might say. Well, that's just an idea, though. It's abstract. It's not eligible for patent. It needs to be created, practically applied.
Or like there needs to be like blueprints or something, right?
Yeah, it needs you need to demonstrate that it's not just an idea on its own in the abstract.
Or like Jean-Paul Sartre, could not patent a philosophical movement, right? Yeah. Okay. So that's what it means to be subject matter eligible. And obviously the Biden administration said that AI raises some questions here. So you've had time to go through, what the US Patent and Trademark Office has come up with to answer the directives in this executive order. So what exactly did they do? What has changed here?
So there are actually two major things that the Patent Office has done. Only the second one is what you're referencing to now with respect to eligibility. And the question now becomes, for this purpose, if I have a computer program, okay, that itself is AI, you have an AI program, okay? I don't want to name any existing brands to single them out, but you can imagine some AI programs right now that the AI tools themselves.
And we're talking about large language models or broader than that?
It's including that.
Okay.
As well as other such things. So now the question is, are those eligible for patent? And the Patent Office didn't actually answer the question directly because it's super complicated. There's so many different examples. Not only that, invention by definition is new. So tomorrow we can have something else brand new. So you can't answer everything from the get-go, but the office has just provided a few additional examples of what might be eligible or might not be eligible when it comes to AI technologies.
And it's probably worth referencing at this point that in most cases, computer software, computer programs are treated as copyrightable, but not patentable. Is that right?
Well, so computer software itself is definitely subject to copyright protection.
Yeah.
Which in and of itself is interesting. It's not really a novel or a poem.
Yep.
Which is clearly subject to it's a fine art and clearly subject to copyright. A computer program, sure, one can see it perhaps if you print it out on a piece of paper and it's a series of characters, it kind of might look to some alien as similar to a novel,
Yeah.
Printed characters on a piece of paper. But the courts for a long time have allowed copyrights on computer software. The question is computer software patentable, patent eligible? And the answer is that it depends, and it sometimes is. If the computer program is presented in a practical way, it actually is a process. Remember, I said the 4 categories from Jefferson and Madison: process, machine, manufacture, composition of matter. A computer program, when loaded onto a computer and activated, now it does something practical. Okay,
I see.
It activates the computer to do something practical, and you can outline the process steps for that. Then in many cases, you could patent that. But you see, this is where the difficulty is. One of the really hard things to resolve, again, we're working with an 18th century statute that just says process. With this brand new technology, computer programs, and is there sufficient practical application in there that's presented in a particular patent application to merit an actual patent? And that's a case-by-case determination. And there are examples that the patent office provides and has been for years on this stuff. But the most recent set of examples from a few weeks ago in the summer of 2025 adds a few more AI-based examples.
Great. Okay, so you said there was two major things that the Patent and Trademark Office did. One of them was not in the Biden administration executive order, and one is this more recent action. What's the more recent action?
Well, this is the most recent action that we just discussed.
Oh,
There
okay.
is an earlier action earlier this year that the Patent Office put out, which also stems from the Biden White House executive order. And it's a question of whether, if a human, which we already discussed, Gregory, which if a human uses an artificial intelligence tool to generate a new invention, whether you have a human inventor such that you're entitled to patent protection in the first place. That is an inventorship question, it's not an eligibility question. And the office has answered that to some extent. And we can talk about that if you'd like.
Yeah, please continue.
Right. So as I did say, the inventor has to be human. If you're interacting with a machine, how much of the invention is made by the human and how much is it made by the machine? And the office is trying to grapple with that question.
Got it. Because like if I am a digital artist and I use Photoshop to create a digital painting, everybody seems to agree that I can copyright that, even though the software of Adobe Photoshop was doing some of the work. However, if I use some of these generative models that can generate images and request it to create a painting based on a prompt, not everyone at the present moment would agree that that is my creation or that I did enough of the work to deserve copyright, right? That's the open question.
Absolutely right. So
Yeah.
if we look, it's the same question on the patent and the copyright side. Using the copyright example is easier to understand for our purposes.
But it absolutely applies in the engineering domain too. For example, Google published a paper, I want to say in 2018, 2019, that was talking about doing actual semiconductor computer chip engineering design work. And they were using a reinforcement learning algorithm to automate decisions about how to design a chip, and not designing an entire chip from scratch, but this process has matured, and now the major software tools that are used to design computer chips include AI-enabled features. And the latest and greatest NVIDIA chips, they are powering AI, but also parts, not all, but parts of that chip were designed either using AI or designed by AI. And so this question that, as you said, is pretty clear-cut in the copyright domain, I feel like it's encroaching upon the engineering domain pretty rapidly.
Absolutely. It's being used right now. So drug companies are using AI tools to manufacture new drugs and new molecules. Many, many engineers use it. The technology is here. People are using it, but the laws are not resolved. And the answers are absolutely not yet clear.
Is the only way for the law to become clear the courts acting? Like, in terms of making the law more clear, could the Patent and Trademark Office issue new guidance, or court rulings the answer, or is Congress going to have to get involved?
So the Patent and Trademark Office did issue guidance on this earlier this year. It's what I was referring to as the first piece. The Copyright Office also issued guidance for copyright. However, this is just the administration talking on how to apply the laws. It's not going to be resolved until the courts rule and/or until Congress issues new laws.
Got it.
And and many people don't agree. Let's just give the copyright example, okay? That you already started with a very good example. Let me give you the actually, a very concrete example that's actually happened, okay? If a photographer goes out and takes pictures with his camera and takes some pictures of a cityscape, okay? Some buildings overlooking a sunset and so on. And it's an actual photograph. And the photograph itself, when you take it, looks beautiful. When you take it with the camera, the photograph is beautiful. And anyway, there's no question that there is copyright protection for that photograph. In this example, the photographer took his photograph of the cityscape and feeds it into an AI machine and gives a prompt to the AI machine and says to the machine, render my photograph into the style of Van Gogh's Starry Nights. I don't know if you remember what that looks like, but
I've done this exact prompt actually, just playing around. I did this, yeah.
Okay, so now the machine generates this new photograph that basically looks like the original photograph the author took, but now looks like a Van Gogh painting to some extent.
Yeah.
Well, the question is then presented to the Copyright Office. Is this new style photograph subject to copyright protection or not? And the Copyright Office has answered this question. It said it is not subject to copyright protection because there is not enough of a human element in there. The original photograph on its own certainly is protectable, but the AI rendition into the style of Van Gogh is all machine, and machine is not a human, therefore no copyright protection.
Amazing. Yeah. So there's folks who are writing or at least involved in the creation of hit songs, and AI is writing part of the music on those hit songs. And so this guidance, I'm sure they're thinking about this as they're thinking about how to monetize their work.
Absolutely right. It's happening all the time. And the same thing is happening on the technology, on the patent side. And the Patent Office issued guidance earlier this year. They gave multiple examples, but it basically says that there has to be what it calls, quote, significant contributions from a human for it to be eligible for patent.
I'm imagining, like multi tens of millions of dollars or hundreds of $1 million of lawsuits are going to hinge on the interpretation of the words significant contribution.
Exactly right. And we don't even know if that's the correct standard. That's what just the Patent Office put out. That's not in the statutes. And it's not what
somebody could go before a judge and say the government is wrong. Significant contribution is a lousy standard. Here's a better one, and maybe the judge will agree.
Exactly. Yeah. Now, let's talk policy for a second here. Let's go back to the Van Gogh style photograph. What happens now? Because currently, this is the situation that we live in the United States. Currently, the Copyright Office is not giving copyrights in an example like that. And you gave another example with songwriters that use AI tools to help them, et cetera, et cetera. What's the practical implication of this? Now, patents, copyrights are commercial instruments. It protects the investment made in time and money to create a new song, a new painting, or a new photograph, or a new technology, a new drug, whatever it might be. And sometimes it's very expensive to create such things. If you spend all that time and money to create something new, and at the end of the day, once you're finished, you cannot market it or profit from it at all because it's freely available to the public, then who's going to make that investment next?
Right.
Take that photograph, for example. Think about a much bigger example where you have an animated movie. We see them all the time from Disney and others. You have an animated movie. Now imagine all that an animated movie is a series of a lot of photographs, right? And imagine that all those photographs, one by one, are created by AI. There's no question that movie production companies use AI right now.
Yeah.
What if they use a lot of it? What's going to happen? Is there somebody going to say that you've spent all this huge amount of time and money to create this feature-length movie, and you have no protection What
Just because
studio?
you used too much AI in your
Right.
process.
Just because
Wow.
you use too much of the tool that's available, or you use the latest and greatest tools, what studio or investor in their right mind is going to make that investment?
Yeah.
Same thing on the patent side. To create a new drug and bring it to market costs on average $2.5 billion. If it's done with AI, that new molecule that is at the core of this new drug, and you cannot get a patent on that, what executive in their right mind is going to invest the billions it takes to bring one of these things to market?
I think it's worth dwelling on this example for a moment because it really gets to the heart of the issue. So, for folks in the audience who aren't familiar, when you're developing a new pharmaceutical drug, one of the first things you have to do is have candidate molecules, right? What is the actual molecule that is this drug that I want to use? And one of the things that you can do to come up with ideas for candidate molecules is you can look through all the research papers that have ever been done about different types of molecules and what types of effects they have on different parts of the body. And so you can look at that research literature, you can come up with a hypothesis that this molecule, which is identical to some other molecule that has been used for a different purpose, or is maybe a derivative of a molecule that is being used for some other purpose, is going to have this beneficial medical effect. Well, once you've got your candidate molecule, maybe you spent a lot of money coming up with the idea for the candidate molecule, but that's definitely not the end of your investment or your hard work. In many ways, it's only the beginning of your investment and hard work, because you've got to run clinical trials to find out if that candidate molecule actually has the effect that you want it to have. And then you've got to go through the regulatory approval process, assuming that the results of your clinical trials are favorable. And your first molecule might not work. So maybe this is actually your 15th candidate molecule that you've put through clinical trials at great expense that finally does have the effect that you want. And you're wanting some kind of financial return based on all of that hard work and investment. And if at the end of that story, somebody says, a judge says, well, hey, you didn't actually have humans come up with your list of candidate molecules. You had a machine learning algorithm do a survey of molecules and generate a list of candidate molecules. And so because you did that, this thing that you've spent hundreds of millions of dollars to discover has this beneficial medical effect and go through the regulatory process, it's actually not eligible for a patent. And so all of your competitors are going to be able to manufacture and sell that exact same drug, but they didn't incur any of the costs that you did to go through clinical trials and the regulatory process. If that happens, it's really scary for what the future of pharmaceutical innovation looks like, because there's much less incentive to develop all these drugs that could theoretically be discovered taking advantage of the benefits of AI. Have I summarized the situation correctly?
Not just correctly, but perfectly. And just one other thing to add, especially in the example of drugs, it so happens that not only is it hard and expensive to come up with and bring a new drug to market that is successful, it also, once brought to market, is easily replicable. There are some things that have a high barrier of entry, and it's really hard to reverse engineer. And even if you have it out in the public domain, it's really hard or almost impossible to figure out how exactly it was done and to replicate the process. But drugs, usually, the chemical formulation, it's really easy to figure out what it is. And once it's out, then almost anybody can make a copycat product. And without the protection of the patent laws, it's very hard to imagine how anybody would go through that whole process, the expensive, lengthy process you described, only to find out at the end of the day, if successful, it's going to be effectively free for anybody to copy.
Yeah. So I think on the one hand, the government wants to make sure that incentives are aligned towards innovation, and they don't want, actually, let me put it another way. For the people who argue that you should not be allowed to patent stuff that is quote unquote invented by AI, I've sort of given what is the sympathetic case to allowing stuff that uses AI to be eligible for a patent. But what's the strongest argument of those who take the other side on this issue?
Yeah, first of all, just to be clear, I don't agree with the other side, but
Yeah.
there's two main arguments that are being made. First, one is just a pure legalistic argument. The Constitution says inventors and authors, and the Supreme Court has said that means human beings, and AI is categorically not a human being. We have to follow the law until Congress changes it, or the Supreme Court changes its mind, or something. So that's a pure mechanical legalistic argument. Then there's a policy argument that is being made that says creation and innovation are pure human endeavors. And that's what distinguishes the human race from animals and inanimate objects, our ability to think and to create.
Yeah.
And when we allow other things into that space, then we diminish the value of human creativity. And if you allow the machines to get protection for all of their creations, they're going to stifle and crowd out the humans, the human creators. You can imagine a machine, a humongous machine sitting in the basement someplace at a large technical company in Silicon Valley. And all it does day in and day out is churn out new candidate molecules in your example.
Yeah.
One after another, millions and billions of candidate molecules. And the argument goes, gee, what are the humans going to do?
Yeah.
But I don't buy either one of these arguments. The legalistic argument is just that. We can overcome that either with a different interpretation of existing law or a new law if we want to. The policy argument, I don't buy either. First of all, at a high level, if there is a new molecule that's going to improve the human condition, save people's lives, cure disease, I really don't care, me, practically speaking, I don't care if who came up with that. I want to improve the human condition. And if you're telling me that I have a new molecule that perhaps cures cancer, and it was created by a machine, but not a human, and therefore it's not subject to patent protection, and therefore nobody's going to invest the $2 billion to bring it to market, then I think that's a really bad policy.
Yeah.
Because you're missing out of important innovation. And you might say, gee, for true blue innovations, like the cure to cancer or whatever, somebody is going to come up with the money no matter what, or the government will give the money. Maybe that's true in some cases. But innovation at scale happens on the margins.
Yeah.
And the question is, what happens on the margins? Are we going to get that extra, additional, incremental innovation? And because that's really where the major changes are being made. And are you going to have the exponential growth in innovation that we have experienced in this country for the past 250 years if you no longer allow protection and incentives on some of these innovations, depending on the tools you use?
That's great. A really terrific summary of both sides of the argument. And I find your take on the issue persuasive, definitely. I want to shift gears to the third topic that you mentioned when you said the sort of big questions, which is what about AI tools to submit patent applications or perhaps even to review patent applications? So one of the reasons why, as you said, the Patent and Trademark Office has 13,000 employees is because they're getting 700,000 patent applications per year. Well, if I can use large language models or other AI design and engineering tools to rapidly create patent applications, maybe that number of 700,000 is going to go to 7 million, which would overwhelm the office, presumably, and really be a detraction from its ability to get the innovations that deserve patent protection, make sure they get it in a reasonable time frame. So I'm curious, what do you think about the U.S. Patent and Trademark Office's guidance for inventors who are using AI to draft patent applications? And what do you also think about the office using AI to review patent applications?
Yeah. As to your first point as to whether we're going to go from 700 to 7 million because of AI, remember, each application still has to reflect an invention.
Right.
So just because you can write applications faster doesn't mean you're going to have many more applications.
Well, I'm thinking about maybe the patent troll problem right now empowered by AI.
Yeah, look, yeah, so it's possible that you have a machine that just generates random applications and starts submitting stuff, even if it's on ridiculous stuff. That can and should be countered by AI tools used by the office itself to review applications faster. In terms of
So you'd be in favor of PTO using more AI tools to review applications?
Absolutely. And when I was the director, we began a very significant project. We hired a dedicated individual specifically to study and come up with new tools for examiners to use, both for patents and trademarks. And the office already is using AI tools more and more as we speak. And hopefully it will get to a point where AI tools will be heavily employed in every single application. So there are at least three major steps in the review of a patent or a trademark application. One is you first take in the application and you have to categorize it. What area of technology are we in so that we can send it to the right experts to review? That's a fairly complex process, actually. Already the office is using advanced tools to generate the initial cut of that automatically. So that's already happening with AI tools at the front end. The second thing is to search for what's called prior art. Has somebody else come up with your invention before you? Because if so, you're not entitled to a patent. So the search for prior art is complicated and can benefit from the use of AI tools. There's more and more, there are many publications out there internationally. You have to search everywhere. And they're on the internet. There's been an explosion in publication. So it's getting more and more difficult. So we really need more and more AI tools for searching for prior art. Already the office is using some. Here, we're not quite there yet, though, because to search for prior art, you have to have text-to-text comparisons, figure-to-figure comparisons, and there is some technology for this, but it's not quite there yet. So the office is working on that. The third aspect of examination is now, once I have both the application and the relevant prior art in hand, comparing the two and doing a studied analysis as to whether the improvement is sufficient to merit its own new patent. We are far away, and I don't know that we will get there in our lifetime because it requires a lot of human judgment to make that fine analysis. AI might help as an initial cut, but we will need, I believe, personally, humans to do that final analysis for quite a long time. But the more the office uses its tools, the better in general. And then the office, once it figures out the best tools, in my view, the office should then share those tools with the public so that the patent lawyers and the inventors themselves can also use them in their own preparation process before submitting the application to the patent office.
That's amazing. I mean, that's a really extraordinary opportunity for increasing productivity at an agency that could really use it, because if you shorten timelines, you could help a lot. So that's going to do it for this episode of the AI Policy Podcast. Andrei, I want to thank you so much. Your knowledge and your depth and your ability to explain complex issues is really unmatched in this sector, and CSIS is lucky to have you as part of the network. So thanks very much for coming on the podcast.
Pleasure to be with you. Thank you very much, and thanks to CSIS for offering this opportunity.
Thanks for listening to this week's episode of the AI Policy Podcast. Be sure to subscribe on your favorite podcast platform so you never miss an episode. We'd also love to hear from you, so reach out to aipolicypodcast@csis.org with your suggestions and feedback. And finally, don't forget to visit our website, csis.org, for our latest research reports and events. This podcast was produced by David Lutfi, Isaac Goldson, Sadie McCullough, Teddy Foley, Sam Gonzalez, and Arena Petrick. See you next time.